opposes that, saying that these properties are no longer available for partition. All of them have been sold in my favor. That is the written statement filed. Then, but the plaintiff was objecting to that. We paid money to the plaintiff, 3.5 crores, and therefore they said we do not want to press these matters. Where the defendant, even according to his written statement, one paragraph in the
You're a defendant.
defendant. In his
In
written
this
statement,
case,
he says these properties have no longer available and it has been sold in my favor.
All right, one name.
Only requesting, Lords, my habit anytime next week. On
Wait,
19th,
no, sir.
But I'll
No
place some more
vacating
judgment.
stay I have granted without
Very well,
hearing.
very well.
Yes.
Lords, please turn to Lord page, the plaint,
Hmm.
which is at page 16, the plaint starts.
Oh, it's not my entry mode. Yes.
Please note,
Coordinate bench is entry mode.
please. Not the, I am not defendant number 12, not in the suit.
Where is your written statement?
My written statement notes will get it at page 54. Now the suit is filed seeking for, the prayer is at page 37. But the prayer is not for partition and consequential division to identify, quantify and allot to the plaintiffs her undivided 1/7 share in the A schedule properties and to put her in actual possession. Not A schedule property, not consists of about not 21 properties. Lords, so please turn to page 38 onwards. They are all not suit A schedule properties. Now, Lord, I am also a family member.
That's not in dispute.
That is not in dispute. Lord, I have filed a written statement at page 54 is my written statement. It is my case that Lord, there was a partition earlier, etc. Lord, that is my contention. And there's another suit that is filed. There's a delay of Lord 48 years in filing of the suit, etc. Now, Lord, please then turn to Lord the compromise petition that is filed.
Page
Page 79.
between whom?
But compromise petition is filed between the plaintiff and defendant number 16. Only two of them.
Concerning what property?
Concerning Lord item number 10 of the plaint schedule. 10, 11, 12.
10 ಒಂದೇನಾ ಎಷ್ಟು?
ಇಲ್ಲ 10 page 90 ಅಲ್ಲಿ 10,
11, 12.
11, 12, 19, 20
19?
and 20.
19 and 20. With regard to all these properties,
Please.
what is your pleading in the written statement?
There are 6 of the.
Lord, I have said that these properties are sold. That is my
Where page?
Lord,
Admittedly, suit schedule properties are self-acquired properties of so and so.
page 54 it starts. Lord,
I am at 56.
please.
Disposed suit property, son, so and so, consequently suit fell in the hands of defendant 15. Therefore, does not intestate. Sold and
7.
was one of the sons of so and so execute registered sale deed in 67 in favor of so and so right.
There is a release deed. I don't think that is
Release
what-
deed. Where is the sale? Partitioned all the properties, so defendants are taking steps on it, by virtue of the partition, they must have disposed all the property. in
Lord, I
favor
am
of-
not the one who had sold it, so Lord, I don't think.
No, the question is not who sold it. Are those properties available today to seek partition?
But there are two issues that come into picture. In a suit for partition, Lord, if it is held by the trial court, that the plaintiff has a share of 1/7 in the property, then
The
automatically.
property that is already sold.
Yes, assuming the court holds so. In that event, Lord, automatically even I'll be entitled for a share. And even the other defendants, Lord, in the suit would be entitled for a share. Now, Lord,
Now, who are you?
Lord, I am defendant number 12, who is also a family member.
Wife of?
Lord, I am Lord Prakash Paul, that is at page
Oh, sorry.
20.
Prakash?
Prakash Paul. At page
Who are you
23.
in relation to the plaintiff?
Lord, I am this Philomena. I think she is my aunt. Lord, page 23, if my Lord turns to. She is my aunt. Page 20, there is a family tree.
Right. Which paragraph in this judgment saying that partial compromise cannot be done in a partition suit?
Yes, Lord. Lord, please turn to para 95.
95?
95.
Ah.
2023 judgment.
Yes.
It is now well settled that under Order 23 Rule 3, as it now stands, when a claim in a suit has been adjusted wholly or in part by way of lawful agreement or compromise, the compromise must be in writing and signed by the parties, and there must be complete agreement between the parties.
All the parties.
All the parties. To constitute an adjustment, agreement and compromise must itself be capable of being embodied in a decree. Now, my lord, here what can the decree be?
Partial decree.
But there cannot be, because my lord, ultimately if it is held, my lord, that they have a share in the property, then even I'll be entitled to it. Then please see my lord, paragraph 96. Indisputably, in the case on hand, plaintiff has not put a signature on the deed of settlement, which was produced before the High Court in the first appeal. The plaintiff has made herself very clear that she never joined in the settlement between her brother, defendant number 1, and the sister, defendant number 2. On this ground alone, settlement could be said to be unlawful, being without any written consent of all the parties. In a suit for partition of joint property, a decree by consent amongst some only of the parties cannot be maintained. But the object is very simple, my lord. What happens is there'll be no proper division ultimately if they succeed. And my lord, it is not a case where my lord, you can pick and choose the properties and file for partition. That is why my lord, the courts have held in a suit for partition, all properties should be made subject matter
All
to suit.
properties should be made.
Therefore, my lord,
separately.
if this property is excluded, the consequence would be there is no one property. Then, my lord, para 97. In Nitya Moni versus so and so, Calcutta High Court observed the decree of subordinate court must be set aside and the whole case retried, because as this suit is for partition of joint property, a decree by consent among some only of the parties cannot possibly maintain. In Veer Singh versus so and so, all the proprietors had not assented to the compromise. The alleged compromise, not having been assented to by all the proprietors, was clearly contrary to law, and the court was therefore fully justified in refusing to enforce it. In para 99, in Tara Prasanna versus so and so, held there can be no compromise binding on all the parties to a suit for partition until and unless all the parties have joined in the compromise. But the object is very, very simple, my lords. In a suit for partition, if you are claiming a right to the property, it should be all the properties, because ultimately there has to be an FDP, there has to be equitable division of the properties. You can't say I will file it in respect of XYZ and delete one of the properties. Enter into compromise selectively insofar as some of the defendants are concerned. Because my lord, multiple properties are sold. It is not only that this property is sold. My lord, multiple properties are sold in favor of various defendants. My lords, please permit me to show even the plain government itself shows so. My lord, please turn to page 32 for a moment.
Sold when?
Not sold, my lord, during 2005, 2003, 2002, page 32. But this is basically, my lord, blackmailing what is being done. But suit is filed in 2020 in respect of sale deeds that executed in 2002, 2003, 2005, etc. After lapse of 15 years, suit is filed. From the date of sale, various sale deeds are executed, which is reflected at page 32.
Now the respondent is a plaintiff?
Please note.
Respondent is a plaintiff or what?
Not the respondents are plaintiff, and also not the person who has entered into
Defendant number 16.
defendant number 16.
Yes, sir.
Well, I'll show before what is his case before the trial court. Lordships may permit me to place on record
Kodi.
his application filed under Order 7, Rule 11 for rejection of the plaint. But in that memo which we have filed now, we have enclosed the application for under Order 7, Rule 11. Permit me to read paragraph 3, not running page 4. This is his case.
Yes.
I state that from a perusal of the averments made in the plaint, it is clear that even according to the plaintiff, the suit schedule properties are the self-acquired properties of late Thomas Appa, who during his lifetime distributed the said properties among his sons, namely, kindly note these names: Anthony Reddy, Arogya Reddy, Chinnaswamy Reddy, Joseph Tyagaraj, and Chauri Reddy. These are the 5 persons. Now let's permit me to take lordships back to the plaint at page 41.
Yes.
There are about 5 items which have been sold in our favor. Page 41, Lord, item number 10. Item number 10, Lord, lordships may kindly note,
Yes.
is sold by Thomas Appa himself in which the petitioner is also a signatory to the sale deed.
Present, this
You read-
defendant number 12.
Even according to him.
Hmm.
All the sons together along with petitioner. Item number 11 now
Hmm.
is sold by Chinnaswamy Reddy. Lordships may kindly note that. Chinnaswamy Reddy. Now, para 3 of the Order 7, Rule 11 application, even
Yes,
according
yes. All right.
item number 12, Arogya Reddy,
Hmm.
one of the sons. Item number 19, again Arogya Reddy.
Hmm. Yes.
Item number 20,
Hmm.
Anthony Reddy.
Hmm.
But according to this petitioner defendant, in his written statement and in his application order 7 rule 11, he says, these were all properties much prior to the filing of the suit for partition. My grandfather died intestate. His sons inherited that and they have all executed registered sale deed. Therefore, the suit for partition should be dismissed is his written statement filed and order 7 rule 11 application. Now, before the trial court, the only other contesting party before us was, but we had purchased it about 25 years ago, was the plaintiff, these ladies, to whom lords we represented that at any rate, it would not be available. Therefore, a detailed compromise petition has been drafted and filed in which they say, since these properties are no longer available for partition, we restrict our claim to the other properties and give up these claims. And they have collected some money also, about 3.5 crores. Kindly see the compromise petition.
ಈಗ ಇವ್ರಿಗೆ ಬೇಕಾಗಿರೋದು ಅಷ್ಟೇನೆ,
ಯಾರಿಗೆ?
ಮನಿ ಅಷ್ಟೇ. What else?
Kindly see, my lord, page number 79.
15-20 ವರ್ಷ ಅಲ್ಲಿ ಸೂಟ್ ಹಾಕೋದು ಅದಕ್ಕೇನೆ.
Then what? No, even according to them, plaint should be dismissed. And they say this is this compromise petition has been.
What happened to the 711 application?
It's pending.
That is pending. But now kindly see, my lord, their compromise petition only, how it has been worded.
Page 95.
Yes. Now, that is the order, my lord. Their claim, they restrict their claim.
Plaintiffs and defendants 16.
Yes. It starts from
Restrict the claim to what?
To the other scheduled properties. Because of this development, because of the admitted case of the contesting defendant that it has been given, they accept that. Those judgment which Malanet friend refers to is when there is a contest between all of them. Even according to the plaintiff, she says that yes, these properties have been given away and they are no longer available for partition. Which
Even
the
according to
defendant,
this defendant also.
even according to the defendant, and we are third party purchasers.
Yes, sir.
Lord, please turn to Lord.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಟಾಕ್ಸ್ ಆಗ್ಬೇಕಾ ಈಗ?
ಇಲ್ಲ, my lord, I want the suit to be dismissed because according to me there is a
A suit
partition.
to be
But
dismissed.
what lord is being done is, lord, the plaintiff lord is picking and choosing lord, and whenever payment is made, he is withdrawing the suit, which lord is impermissible in law. Lord, I may have filed a rejection of claim. There is no difficulty. I am not disputing that fact. But the question would be in law. But can the plaintiff pick and choose property and say, I am only going to proceed against this property? Now, please turn to page 32 for a moment. The sale deed that is executed in favor of the defendant number 16, not is not executed by me or by my father.
No, signatory there. I produce
He
that.
never said
No, in that.
you are the witness or signatory.
No,
whatever.
signatory.
Maybe
as a
I-
attesting.
that may be true. I'm not.
No, page number 9 of that memo, Lord, which we have filed now. Page number 7 is the sale deed. Page number is the 7 is the sale deed, Lordships get it.
What's the petitioner's name?
Prakash
Prakash Raj, page number 9, Lordships will get.
I'm there.
11, item, serial number 11.
ಪ್ರಕಾಶ್ ಪಾಲ್ ಇದೆಯಲ್ಲ.
Very well.
ಮತ್ತೆ?
I stand alone. Plaintiff
ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಟಾಕ್ಸ್ ಆಗ್ಬೇಕು ಅಷ್ಟೇ, ಈಗ ಬೇರೆ ಏನಿಲ್ಲ. ಅವ್ರು 3.5 ಕೋಟಿ ತಗೊಂಡಿದ್ದಾರೆ, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ನಿಮಗೆ ಎಷ್ಟು ಬೇಕು ಅಂತ ಅಷ್ಟೇ.
ನನಗೆ ಹಂಗಲ್ಲ.
ಇನ್ನೇನಿದೆ?
My point is only
ಈ
this. Please,
ಆಫ್ಟರ್ 20 ವರ್ಷ ಎಲ್ಲ ಹಾಕೋದು ಇದಕ್ಕೇನೆ.
that is why Lord, I'm saying Lord, suit itself is not maintainable. But Lord, it cannot be a case where the plaintiff will say, Lord, I will pursue my case against this particular property. Leave rest of the properties. Please look at the situation.
Even according to you, those properties are not available at all.
But I may say that the property is not available, but please see what the plaintiff says. The plaintiff says these properties are available.
You forget about the plaintiff.
No,
You say that it should be dismissed because none of these are
absolutely,
available.
Lord. No doubt about it. But kindly see, Lord, the issue would be
Arm twisting tactics.
not arm twisted
Nothing
tactics by
else.
the plaintiff, Lord,
Oh,
not by me. The plaintiff is trying to say, Lord, I will take one property, let go of that property. Please see what is there in the compromise. No, plaintiff says, kindly see what happens is, if this property is let out from the case, the consequence.
Not even available.
No, not That is precisely the case, Lord.
25 years ago, sale deed has
In
happened.
that event, Lord, the entire
This
plaint
is
has to go.
permitted, then gone.
But in that event, the entire plaint has to
For
go.
that, they have to pursue
711
order 711.
711
Lord. Then, Lord,
Court will answer
what
that.
will happen is, Lord, till then, Lord, what happens, kindly see the situation. So once this property is not left out of the partition, tomorrow, Lord, the property is not available for division, Lord, insofar rest of the parties are concerned.
No problem.
And, Lord, the judgment of the apex court, Lord, is
That I will
directly.
consider, no problem.
Very
We'll
good.
pass orders on Tuesday.
Please,
List on 19th. Yes, at 4 PM.
the interim order may be extended.
Interim order will continue. Interim order shall continue to the next date.
But I'll place on record some more judgments,
So
Lord.
there is one judgment of Justice Nataraj. In a partition suit, nobody on earth can stop compromise between the parties qua certain properties.
Place on record.
Gulwa,
That's what.
a detailed consideration of all the judgments of the apex court, including this.
Right. Very well, I'll have a look, please. Ultimately, Lord, if the plaintiff is not let go,
Ultimately settle ಆದ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ.
ಅಲ್ಲಿ ಎಲ್ಲರನ್ನು ಬಿಟ್ಕೊಟ್ರೆ ನಮ್ಗೆ ತೊಂದರೆ ಇಲ್ಲ. ಈಗ ಒಬ್ಬೊಬ್ಬರನ್ನ ಬಿಟ್ಕೊಂಡು ಹಿಂಗ್ ಮಾಡಿದ್ರೆ that is the difficulty.
711 application. Yes.
The court observes something on that nature, Lord, I'll be grateful.
You will withdraw the petition? No problem.
ಹಂಗಲ್ಲ. It's
Let the court answer 711 application, you withdraw the petition, all contentions remain open. That's all.
no, if they withdraw the suit, Lord, I have no difficulty.
No, it's not the plaintiff.
No, the plaintiff is the one who is not entered into.
711 application, rejection of plaint ಮೇಲೆ ಆಗ್ಲಿ ಬಿಡಿ.
Right.
What do I do? Close it?
No, have it on Tuesday.
Then no problem.